right to work check and 28 days grace period for employers. Every employer in the UK is required to do a right to work check on every employee that they are going to take on board, they are going to offer employment to. They are required to do the digital check, not a physical check. The physical checks are completely gone. The right to work guidance only refers to the digital checks where the individual proposed employee, prospective employee will have to generate a share code and show their status digitally. So which means the share code is given to the employer with their date of birth. The employer checks the share code and confirms whether the person has a right to work. If there is a limited right to work, they confirm it accordingly. They put it on their records for their compliances. If you're a student, they would need a letter from the university saying you are allowed to work 20 hours or whatever is your right. If you have time limited, for example, you have a spouse visa, they are required to record the end date, and then they would check before that end date with you if you have applied further leave or what is going to happen in future. So they are required to keep all those documents and check. One of the important things in the latest right to work guidance has been added is there is a 28 days grace period. Many employers don't allow this, and because they are worried of the penalties which are going up 40,000, 60,000 and above, whatever the pricing is going on, all these civil penalties for employing someone who doesn't have the correct appropriate right to work. So employers are a bit over careful, or they are cautious about this, over cautious. Just to update, as per the latest guidance, employers who have done a right to work check, they do have, let's say your permission ends, the individual's permission has ended on 31st of December. From that date forward up to say 28th of January, 28 days after the permission end date, the employer does have a grace period where they can continue employing the employer. They cannot hire the person new. If it's a new employee, they cannot do that. They need a positive right to work check. But if it's someone whose right to work check they've already done, they are working, they have a limited permission, time limited permission, let's say that is expiring on 31st December, they can do the right to work check again. There are some challenges. Let's say the individual has filed an extension or some application and they have not enrolled their biometrics. The right to work check may not come positive. That's just a system issue. That's a validity issue also. Unless the biometrics are enrolled, the new application is not valid. So right to work check will not come as positive. It is quite highly likely that happens usually if the biometrics are not enrolled. The employer still has a grace period of 28 days. That is, if the permission has ended on 31st December, up to 28th of January, the employer can still continue to employ and keep on doing the right to work checks again and again. They have the option of doing it again and again. There is nothing wrong. If once it comes negative, they can get more documents, more information, or if the employee has informed them that, oh, I've already enrolled my biometrics now, can you do it again? So they can do it again and give the opportunity to the employee. Up to 28 days, there is a grace period. Employers will not be penalized if they are making reasonable and genuine efforts to try and check the right to work for the employee, either through the employer's checking service, whatever they're trying to do. So if genuinely it is a problem that the important thing is the employee has already been working for the employer, and some right to work check might have definitely been done in the past. That's one part. And secondly, that particular permission is ending and the employee has made a new application or trying to sort out whatever it is, an appeal stage or something is happening. In that case, there is a 28 days grace period that the employers are allowed. A civil penalty will not be issued. That's what the guidance provides. If you wish to consider, read the guidance properly. You can take immigration advice from lawyers. We do advise on right to work matters also to individual employees, to employers also. If you want any advice on this, help with right to work, confirming with the right to work or assessing anyone's right to work, etc., we can help with all those matters. So book a paid consultation with us if you need any advice on this area, and we can advise you on that. We do provide paid advice only. We don't provide any free advice. Thank you very much.